The rule of law is an ideal that has shaped the laws and procedures that govern and protect us as citizens and provides the basis for our justice system. It is not the rule of law that changes, but its interpretation and implementation. During the American Civil War, both North and South sought to interpret the rule of law to justify their specific legal standing. On September 28, 2011, a small group of experts gathered to discuss the rule of law as it was used during the Civil War. With the beautiful and appropriate setting of James Madison's Montpelier for a meeting venue, here is what the experts have to say on the different applications of the rule of law.
Good evening. Good evening. We're just so happy that you've come to join us this evening for this rule of law event. Without question, the rule of law is a significant issue that's impacting this country every year with cases all the time. But tonight we're going to go far, far back, and we're going to look at the rule of law as it relates to the Civil War. And to tee that conversation up, I'd like to introduce to you Mike Pace. Mike. I didn't mention your father.
No, that's quite all right. Thank you very much, Doug. It is a privilege to be here. I want to thank you and your staff for setting this room up and letting us come to James Madison's home and have this event here. And I particularly want to thank Andy Washburn, who's done a terrific job. And let's give a round of applause to Andy and the staff. My name is Mike Pace. We have this project called the Virginia Bar Association Rule of Law Project. Now, I've been asked to explain the blue bands. These are gifts. These are gifts from the students who receive rule of law education. The Virginia Bar Association Rule of Law Project has the purpose of changing fundamentally the way the rule of law is understood and taught in America and in other countries based on democratic principles. We go into classrooms matching teachers in public and private schools with local bar association members, lawyers, and judges to team teach. And so Erica became sort of the star of our show. It's a web-based curriculum. We provide teachers with lesson plans and the resources they need to teach the rule of law at what we call the fundamental level. It seems to us, based on our research, that all education in public and private schools at the middle and high school level strikes 2 rungs too high on the ladder of understanding of the rule of law. They talk about the blocking and tackling of civics, which is separation of powers, the Bill of Rights, the Constitution, and those things that you learn in 7th and 8th grade civics. But it doesn't hit at the fundamental heart of the matter, and that's what we do. We teach the kids that fundamentally the rule of law is the basis for all civil societies, and especially the American experiment. Simply put, from what we do, and the rule of law has many definitions, and it's ancient. We didn't create it. We just put our spin on it. But basically, kids get this notion. All of the things that we have when we talk about the Constitution and the fundamentals of government spring from the notion that the people are instrumentally involved, directly connected with the making of laws. Those laws are to be fairly and equally applied to everybody, and the secret sauce. We agree by contract with one another that we will obey those laws. That's not being taught in public schools today, and it's not the teacher's fault. They're doing a great job. They are doing a wonderful job with the time and the resources and the talent they have, so they need help. So that's what we do. Erica was trying to figure out what this weirded out phrase, the rule of law, means. She's 15 years old. She's the star of the video on our website, and I invite you to go there and see her. But one day after videotaping, she said, I get it. I understand it now. The rule of law simply means the law rules. So every teacher, every student, everybody involved in this project, and now you have one of these, which is sort of the hallmark of where we are. Thank you for letting me go that deep, and now let me go on with the show. Abraham Lincoln said, teach the children so it's not necessary to teach the adults. That's what we're about. Only through education can we raise the level of understanding about what the rule of law is fundamentally. so we understand it and become active and engaged citizens as we grow into adults. So, the rule of law is the essence of who we are. I'm a quote guy, so I'm going to give you my last one. John Adams said, "There's never been a democracy yet in the history of the world that did not commit suicide." Our project and what we're doing tonight is designed to prove him totally wrong. What we have for you tonight is one of the education offerings of the Virginia Bar Association Rule of Law Project. The Rule of Law Project is funded by a generous gift from the Virginia Law Foundation. And we are about educational opportunities for not just middle schools, but high schools, colleges, graduate schools, and civic groups, and audiences like you. So thank you for coming. We're very appreciative of the partnership that is developed and believe will continue to develop with the Center for the Constitution here at James Madison Montpelier. What a beautiful room. What a very inspiring, awesome place this is, isn't it? Yes. Fabulous, just fabulous. Now, tonight's discussion is moderated by my partner in the Rule of Law Project, the gentleman to my far right, Tim Isaacs. Tim is a master educator. He has a career of 42 years in public education. 28 of those years were spent in Fairfax Public Schools, where he was a teacher, administrator, and coach, a stint in Lancaster, Pennsylvania, and then most recently, and retired from, being the director of curriculum instruction in Roanoke City Public Schools. It was a great day when I met Tim when we were birthing this project. He is going to moderate tonight. He is the education coordinator of the VBA Rule of Law Project. Now, for our star-studded cast of characters to my near right, they are famous, they are renowned, they are scholar, expert historians, and they are sought after everywhere to speak, and they're here to speak with you tonight. To my far right, Christy Coleman is president and CEO of the American Civil War Center at Historic Tredegar. She is famous, she speaks everywhere, and she is an expert in her field. One of the things that you should know is that before she took her current job, she had a number of other significant roles in museums of note, particularly one at a museum in Detroit, and she spent an awful lot of time in various roles at Colonial Williamsburg, where in 2009, as a result of her work for Colonial Williamsburg Productions, she received an Emmy for Outstanding Educational Programming, and we're glad to have Christy with us here. To my near right, and I'll leave the gentleman in the middle aside for just a minute, we have Liz Varon. Liz is a professor of history at the University of Virginia. She specializes in the Civil War and 19th century South. She is a prize-winning author, a very prolific author, and has written works on women in the antebellum South and the Civil War. She is beginning a new book on Lee's surrender to Grant at Appomattox. I asked her how it was going. She says she's trying to figure out how she's going to get it done. That will be fun to read when it comes out, and I want to be in her class. And then last but not least, Waite Rawls. Waite is the executive director of the Museum of the Confederacy. He is a lifelong historian. He took a divergence and spent a career as an investment banker and then made his hobby his life's work. He's a VMI guy. He is also a graduate of the University of Virginia, where he got his MBA degree and his JD. He has many, many civic, educational, and charitable boards that he serves on as a community servant. We're very glad to have them here. We're very glad to have you here. We hope you enjoy the show. And partner, it's all yours.
My job is to simply ask a series of questions on 4 distinct topics. And those topics are the sovereignty of the people versus the sovereignty of the government, legislative law versus higher law, war powers during the war, and then the legacy of the war, all viewed from the perspective of the rule of law. What I would like to do is give you a little bit of background, put all of this in context. The dilemma for the rule of law during the Civil War grows out of the tension of 2 distinct definitions of the rule of law. the rule of law in theory, which is an ideal, and the rule of law in practice, circumstantial, situational. This tension has its roots, whether we're focusing on states' rights, the constitutional legality of secession, economic sectionalism, or slavery, in the unfinished business of the Constitutional Convention, and perhaps the framers' understandable oversight and expediency in drafting a document the world had never yet seen. The tension continued into the 19th century, unresolved, complicated by such things as growing regional, political, and economic tensions that the Constitution, as written, never even considered. The tension between the two forms of the rule of law continued to cause problems for leaders on both sides of the Mason-Dixon line. Lincoln and Davis both faced the same issues, and at times sacrificed the very ideals of the rule of law that they felt so sacred in order to meet the expediency and the necessities of the time. Since the war ended in 1865, we, the people, have continued to live this tension in disputes over the limits of presidential power, states' rights, a completely enfranchised citizenry, the imposition of the federal government in our personal lives, judicial independence, and even the right to fly the Confederate flag and the right to post the Ten Commandments in our public schools. From 13 free and independent colonies bordered by the Atlantic and European monarchies on one side and the unknown western frontier on the other, the best minds of the period squabbled and cobbled together a political system that is still the envy of the world today. The tension between Federalists and Anti-Federalists that then existed found new champions in Abraham Lincoln and Jefferson Davis, respectively, during the war. This bloody war may have reunited the country, but did not end the tension. Reconstruction, Jim Crow, the civil rights movement a century later proved this. As we become an ever more pluralistic society, the tension between these two forms of the rule of law has not diminished. From the 1780s to 2011, this tension has been about a single issue that goes to the heart of human existence, an issue Abraham Lincoln summarized so eloquently in 1838. The truth of a proposition, namely the capability of a people to govern themselves. We are gathered this evening in this beautiful home of James Madison, architect of the Constitution, to listen to our three distinguished scholars discuss the dilemma that split the Union and tested the very existence of our nation and the strength of our Constitution, the very embodiment of the rule of law. I have already outlined for you the four topics we're going to discuss, so let me begin by asking the first question on our first issue, sovereignty of the people versus sovereignty of the government. While the debate regarding popular sovereignty versus sovereignty of the government was not new to people of the mid-19th century, the debate took on a new urgency for both North and South as they struggled to define the nature of this relationship. At the heart of this debate is, of course, the issue of states' rights, a term most of us are familiar with, some may know intimately. But what exactly did states' rights mean to the two opposing sides and their leaders?
I'll jump.
Go for it.
So let me just suggest that there are really two states' rights positions, and they're a subject of some controversy within each section, North and South. So there's division. on each side, within each of the two sides. There's what we might call a moderate states' rights position that was really quite mainstream. And this was an extension of the Madisonian idea of dual sovereignty, that at the moment of the founding, the people vest some power in the states and some power in the federal government. But it was a variation, this sort of moderate states' rights philosophy, that emphasized that the federal government's powers were few and defined and the states' powers were many and indefinite. And this version of states' rights was very popular. In the North and in the South, it was an article of faith of the Democratic Party, of Andrew Jackson and Stephen Douglas and Roger Taney and so on. But then there was a more extreme form of states' rights that we associate with Calhoun and eventually with the secessionists. And that was the idea, based in a compact theory of government, that at the time of the founding, the states form the union. They compact to form the union. And that union is their creature. It is there to serve them. The union has duties to them, but not really dominion over them. And if the union really can't constitutionally pass laws inimical to the rights of the states in that more extreme version. And it's important to realize that both are there because Southerners clash over these two versions in the nullification controversy, Jackson and Calhoun and so on. And the secessionists have the challenge of trying to persuade Southerners that all those who believe in states' rights need to come over to and adopt this more militant version of it.
Well, I think one of the interesting challenges when we're talking about the rise of the more radical version of that, using your thesis, is that there are other elements here that begin to play to why that becomes, that radicalism, if you will, extends itself. And it's one that often is missing from the conversation about early nationhood. And that conversation is that we have to first of all recognize that the Constitution that we hold dear is actually the second try at this. The first try that gave all of this power to the states, it didn't work. It continued to have problems. So there was a greater idea, I mean, the preamble itself says to form a more perfect union. And so that's an element that often gets dismissed, but tied up in this, particularly for those in the South, is that the country is radically and rapidly changing. Political power had been held in the South essentially for the first 70 years of our nation's existence. And that power was being challenged, not from within per se, but that it was being challenged by all of these others that were coming into the country. All of these others who didn't feel like they wanted to compete with and wanted to be able to compete in a free market environment. It came from a transition from what the world really knew in terms of agrarian society. America was a remarkable experiment on so many levels, and we have simplified this to the point, particularly in our modern discourse, that is really false about who we were as a nation at the time. And so I would argue that we have to remember that the nation is in this flux period. We have to remember and recognize the brilliance of those who wrote the document to begin with, that it was meant to be a living document. They knew they didn't have all the answers. I just read something recently about all of the amendments that didn't make it into the Constitution. And so, again, they recognize that there are certain elements that as the nation matures and as it grows and as it tackles, that the nation will decide. And who is that nation? Which is, I know, your next question. But who is that nation becomes that dynamic between this idea of the individual, we the people, versus the Republican form of government that we had set up. And I think that that is another interesting conflict that isn't often brought into play. You know, we elect others to represent us, but are they really there to represent us, or are we putting them in position because we think that they know best? And when you are looking at a society, particularly what established itself, so not only just in the South, this was going on in the North as well, the idea of the blue blood or the Virginia red families, Virginia bred families, that a whole society was based on a notion of your betters. And so, again, I'm just suggesting that when you combine all of these factors together with what Liz has shared with you, it becomes a much more complex story. It is not simply a fight over whether or not we want to control the size of government. It is, what is this government going to be flexible to the needs of a growing nation? And as we are growing and as we are being challenged by all of this, how do we maintain the appropriate balances? They hadn't figured out all of the problems that could exist. And so the 10th Amendment is there to provide a certain level of flexibility. But I would argue that it doesn't mean that if it's not written in those first 9, you can't do it. It just means that at the time, we have to be a little malleable here with a growing nation. It is a compromise amendment. Wait.
I think it's hard for us today to understand the debates that were going on in the 70 years between the writing of the Constitution and the Civil War. In our lifetimes, the federal government is the big deal. They write the laws. They regulate our behavior. They collect the taxes. They spend the money. Back then, the federal government delivered the mail, and that was about it. It negotiated treaties. Supposedly, it raised armies for the national defense, but in the War of 1812, New England said, we're not going to give you any troops. So they couldn't really they raised an army from a section of the country. So the Federalist argument was an argument in theory, not an argument in fact. Today, it's an argument in fact. I mean, who should be writing laws? Should it be states or federal government? It's a fair contest today. But the idea that the founders would think that the federal government would write a regulation for what kind of label would be on Montpelier's water, there's no way that they would do it. So the debates between the Federalists and the Anti-Federalists there was more of a connotation to states' rights than just something called states' rights. And we're going to talk about secession from time to time during the evening. One of the big issues was secession. It's not like Rick Perry threatening to secede and everybody kind of giggling. For 70 years, people threatened to secede because they didn't want to give up the power of the state to a federal government that may or may not agree with them on any given moment. And the threats to secede were all over the country for all sorts of different issues, and they either got put down because the issue wasn't big enough, or in the case of the nullification crisis, Andrew Jackson's stick was bigger than South Carolina's stick. But there was disagreement over this. There was disagreement over what the framers thought and what they intended, and how should we judge that. There's a terrific article in the recent issue of the Virginia Historical Society Quarterly that talks about one of the great jurists of the Founding Fathers era, St. George Tucker, and his two sons were great jurists, and they were both anti-federalists. But they disagreed vehemently with each other over whether the anti-federalist argument could be extended as far as the right of secession. And they disagreed. Now, one of the things that the founders and all of us in the 200 years plus since then have agreed is that's where the rule of law is supposed to step in. You're supposed to get lawyers with some basic understanding of either a piece of legislation or the Constitution to referee between disagreeing parties. And quite frankly, I think on the subject of secession, since 1787 until 2011, the rule of law has wimped out. The Supreme Court has only ruled on the right of secession once, and that was in 1868 in a split court. The decision, majority decision, was written by William Seward, who was one of the leaders of the Radical Republicans. And it was an incidental case having to do with whether Texas could enforce something during the war. And so the question was Texas a state or not? And Seward wrote in the majority opinion that certainly Texas was a state because it couldn't have seceded. Now, for William Seward in 1868 to write anything other than that, his only alternative would be to write an opinion that said, oops. Well, he couldn't write an opinion that said, oops, 600,000 guys just died for the wrong reason. So he had to say that. And that's the only time that the Supreme Court, who's the ultimate rule of law, that's who we depend on. That's why we've got three branches of judgment. So you know, I wish something would come up. I wish Rick Perry would do something to bring it to a head so that so we could quit talking about it, because we've been talking about it since Madison and the others had their debates.
The next question is directly linked to the first, and actually Waite touched on it. Lincoln said in the first inaugural address that no state upon its own mere notion can lawfully get out of the Union. Davis, on the other hand, declares in his inaugural address that since the government had become destructive and perverted from the purposes for which it was ordained, the states had a right to separate existence and independence. How do these opposing comments about secession define the nature of government sovereignty, North and South?
You go first.
Okay, sure.
I think Jefferson Davis really screwed up when he said that. It's interesting. We, in the creation of our country, there are two of the two basic founding documents were the Declaration of Independence and the Constitution. And the Declaration of Independence says, if you read it, and I hope everybody reads it carefully, it's about a paragraph of beautiful prose, and then it's bitch, 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 bitch. And then it says, in conclusion, we're out of here. Okay. The Constitution sets out the rule of law. The Declaration of Independence breaks the rule of law. It defies the rule of law because it says, King, you setting the rules, we don't like them, we're out of here. Okay. So in this quote, Jefferson Davis is talking about the Declaration of Independence, which is not what the southern states did when they seceded. They invoked the Constitution. Perhaps they should have invoked the right of rebellion, but because that's what the Declaration of Independence is doing, and that's what Jefferson Davis is doing in this. When we no longer believe in a government, we will rebel, we're out of here. And that is throw down the gauntlet, pick up your guns. You are either going to force us to stay part of it or we're going to fight to leave. Okay, but that's not what the Confederate, or that's not what the individual states who later formed the Confederacy were doing. They invoked the Constitution. And they invoked this hardline, anti-federalist line of thinking about states' rights. I can't remember whether it was Henry Tucker or Beverly Tucker, but it was his line of thinking that said, if you just can't take it anymore, the one big right retained to the state is to withdraw. And others disagreed with him. I mean, most particularly Abraham Lincoln disagreed with him. So I think that Jefferson Davis screwed up with that quote.
I'll chime in by reminding us that Lincoln says of secession that it's the essence of anarchy. What he means by that is, first, that he believes it to be unconstitutional, but second, Lincoln viewed the South, as the Republicans did, and as many Americans did, as mired in lawlessness. They believed that the South was a lawless place and that secession was a lawless act in keeping with Southern lawlessness. And as they looked around the landscape and rehearsed the history of the past 20 or 30 years, they saw what they thought was a lot of evidence of lawlessness, that slaveholders, this haughty oligarchy, believed themselves to be above the law. That's why they still dueled when most Americans thought that that was an archaic tradition. That's why when Preston Brooks caned Charles Sumner on the floor of the Senate, Southerners, white Southerners rallied to his defense. That's why they approved the actions of the border ruffians in Kansas, pro-slavery Missourians who streamed into Kansas and imposed a pro-slavery government there. He believed that there was a widespread lawlessness in the South, and that secession represented a repudiation of the rule of law. Because another way of thinking about this is that the rule of law is lodged in the Supreme Court. It can enforce the rule of law. But I think for Republicans like Lincoln, the rule of law was lodged in the electoral system. The electoral system set out rules of play. And the Confederates had repudiated those rules of play. They had said, well, we didn't win, so we're out of here, to quote Waite. And I think for Lincoln, this refusal to abide by the verdict of the electoral system, to say, okay, the Republicans won fair and square, but we don't care, that was fundamentally lawless. That was an abrogation of the rule of law. On the Southern side, Davis and the others who ground secession in the Constitution believe that secession is constitutional at the time it occurs, because again, they're going back to this compact theory of government, that these sovereign states had formed the Union, and they believed that the North had breached the terms of the contract. So secession was a lawful remedy for breach of contract. That's really how they saw it. And we can get into this issue a little bit more later on, but for secessionists, the main sticking point, the sign of Northern bad faith, was the fact that Northerners had not abided by the fugitive slave law.
Nothing to add.
Let me respond to one thing. And don't everybody get me wrong. I'm an admirer of Abraham Lincoln. I think that his learning curve was as straight up as any American president. He emerged as one of the greatest, but I think his first 90 or 120 days was perhaps the worst 120 days of any American president in history. If the rule of law resided in the Supreme Court, I think Lincoln was a smart guy. And he looked over at the Supreme Court and says, Roger Taney.
Yeah, right indeed.
Let's see, he wrote the Dred Scott opinion, didn't he? I haven't got a chance over there in the halls of the Supreme Court. Now, if I turn to the populace, that guy Breckinridge got almost as many popular votes as I did, and I didn't get but 40%. Dang, we better not take it to the people either. I better do it myself. And he assumed a power that wasn't there. Now,
on the other hand, Wade, I think Lincoln's presumption and the presumption of the Republicans was that even the election wasn't a fair fight, because the critique of the Republicans of the South was that the South was a society in which there was no free speech. No Republican, unless he wanted to put his life in danger, was going to campaign down there, just as no abolitionist was free to go down there. So I think there was a sense that this, in some sense, the absence of real freedom of speech in the South meant that Lincoln didn't have a chance to take it to the Southern people. And of course, the fact that he felt he didn't have a chance allowed the Republicans to nurture this fantasy, which is very persistent, that there's a kind of latent anti-slavery yeomanry in the South that's going to rise up and assert itself once the sort of thrall of this slaveholder regime is lifted.
Well, Liz, I agree with that. I think that one of the things that you see in those critical early days between the election and the Lincoln's call for troops, which was the critical period of transition, was that both sides simply didn't understand the other side, and almost every judgment that they made was wrong. That Lincoln did believe that he was not welcome in the South, and that the fire eaters were the big money guys and nobody else in the South would follow him, and it was just wrong.
Absolutely.
The Southerners thought, and don't ask me why, that they could leave in peace. And they were just wrong. I mean, one of the reasons that the that both parties, and it is interesting that both parties picked a moderate, or both parties, the Confederates, when they picked Jefferson Davis, they did not pick one of the fire eaters. They picked a moderate. In the Republican Party convention, Lincoln finished 4th in the first vote. I mean, he was the moderate that nobody knew. And so, I mean, one of the reasons that they picked him is let's soften the blow as much as we can with Lincoln. And it didn't work, and they still made these big misjudgments. But I agree with you that of what Lincoln thought, and that did drive a lot of his decisions. And you know, he was just wrong.
Christy, did you want to? Okay. Let's leave the presidents for a moment and move to the second issue, or we could be here all night. In talking about legislated law and higher law, first question. For both North and South, legislated law finds its legitimacy in the two nations' respective constitutions. Sometimes we seem to forget that the South did indeed have a constitution, and that constitution was modeled pretty much on the U.S. Constitution. The Confederate version sought, however, to remove some of the legal ambiguities they felt existed in the model. The question is, what ambiguities did they seek to legislate, and were these moves completely successful in accomplishing the desired effect?
Well, they wanted to enshrine this compact theory of government in their constitution, so they refer to the sovereign states coming together, each state acting in its sovereign and independent character, it says in the Confederate preamble. But of course, the big issue is they wanted to resolve ambiguities where slavery is concerned. The word slavery isn't in our federal constitution. Slaves are persons held to service or labor, because the founders were, squeamish and ambivalent, many of them, about slavery, and the Confederate Constitution was designed to be very explicit about its support for the right to own slaves. Slavery is given explicit protection. The word is used. There's an express ban on any law denying or impairing the right of property in slaves. So that's the principal clarification, if you will.
And it also speaks to any future expansion of the country. Under the Confederacy, right, that the question of slavery will not be an issue. It certainly will be a part of it. So these two constitutions, if you will, really, as has been said in the question, it really did address, the Confederacy Constitution certainly addressed ambiguities in that the U.S. Constitution did not. And I think that is important in terms of laying the groundwork of what kind of nation they were striving to be. And the amount of not only state but individual rights that they were striving to have. Now, what I think is interesting in all of this is that the start of this question is about the rule of law versus the notion of higher law. And higher law being whatever that moral center is. And this is another social, socio-political, if you will, but really more of a social dynamic that is at play during this period. Is that roughly from 1840s on, North and South both view each other as completely corrupt, morally bankrupt societies. Both view each other that way. And it's a very interesting thing. For Southerners, the North has become a mean, greedy place where all people are doing is chasing after money, creating, earning wealth without really producing anything, right? They're not producing anything. They are out here just making money, and they are speculating, and they are, and any old body can be any old thing. And the women, my Lord, the women are in these factories working, and it was really quite remarkable. Now, for the North, this seemed quite, again, morally bankrupt to them, looking southward. How dare you talk about we don't produce anything? You have an economy based on the labor of people who work for you, whether you own them or not. Your society is based on this system. Your society is based on a hierarchical system that is not based on the merits that an individual may have. It is based on a familial or an inheritance that and property transfer and all of that just keeps, how can a person who has great ambition and great talent come to have wealth or come to have station? I mean, they get into some really interesting things, and then they start throwing Bible verses at each other, right? They start throwing Bible verses at each other, and when that doesn't work, they throw the Declaration back at each other. And it just goes, it's really quite remarkable, the realities that were at play. I tell people that come to the center and during the course of my public history career, because you see, essentially, our job is to, bridge that divide, if you will, or bridge that gap between the academics and the public. That's our job in our institutions, to try to make this plain for you. And so, but this is one that people just look at us sometimes and scratch their heads and say, wait a minute, you're talking about all this other stuff, but what about the black people? And you will note that in the course of our conversation thus far, I have personally decided to sit here and watch this for a minute. Nobody's talking about the enslaved population and what they want and whether or not they have a right, a human right. And because biblically, this is an institution that is supported and understood since ancient times. The world over has had various forms of slavery. What made the American system so dramatically different through anything that had existed through millennia was its number one, the sheer numbers. This is the largest forced migration in world history, number one, into the New World. Number two, this is a system that has really placed human beings into the form of chattel. And so the bottom line is, there is a recognition of humanness, but not necessarily humanity. And so when you're struggling with these questions of moral or higher authority, the challenge becomes that oftentimes we're leaving 20% of the population out of the conversation because they are not silent. They are not silent. They are expressing themselves through their action, whether that is what we refer to as passive resistance in the field. I'm sick or I'm stupid. Either way, I'm not doing it. Okay? Tools that end up down the wells. Archaeologists at these historic sites will tell you time and time again the stuff that they find in a well. Well, if there were slaves there, guess what? It broke, massa. I don't know what happened to it. And then you have, obviously more aggressive or more active resistance. Poisonings, burnings, arsons. You have running away, which is, people did it with their feet. This is not a group of people who are happy with their condition, who have just the best masters that take care of them all the time. Now, I admit some relationships, because all relationships, ultimately, there are certain intimacies that develop. But the bottom line is, if I can sell your child, hell, if I can name your child, you cannot ignore that dynamic in the way that these societies are viewing each other. So, and again, let's not misunderstand. The folks in the North have no great love for the Negro. Let's not confuse this. For many in the North, while they abhor the institution, it isn't necessarily about black people. It is the institution and the things that they understand and associate with that institution, and a corruption that they believe that institution fosters. A corruption that, most people are striving for this planter society, is this so-called cavalier society, when with higher learning and gentility and all these things, but will never, the attainment of that means that you will never get your hands dirty, that you will never feel the root of your labor. And furthermore, that a man's labor should determine his course, not someone else's. So these are very real dynamics at play. And the rule of law, oftentimes, on both sides of within these two governments, even as the Confederacy strove to eliminate those kinds of ambiguities in the rule of law, the fact of the matter is there is still a tension even within the Confederacy, because what another thing that over 150 years, everybody in the South and everybody that was in the South and was white was absolutely rah 100% for the Confederacy. I would encourage you to go and take a look at the digital library that the University of Richmond has. They have done a remarkable project where they have actually gone and looked district by district at voting patterns, both for the 60 and the 64 elections. And what you see is a whole lot of purple, where people are voting for unionist candidates, where they are voting for, it's really interesting to see. So, I'm sorry, I think I'm speaking far too much, but the point that I want to make is this whole issue of higher versus rule of law does drive the actions of the people that today we would refer to as radicals. It is driving the behavior of the abolitionists. It is driving the behavior of people who say, there was mentioning of the Fugitive Slave Act. We are not going to enforce that. We think it's an ungodly law. We are not going to enforce it. So, those tensions continue. I mean, they continue to this day. Wait.
Do you want to say something, Wade?
Of course he does.
Yeah. I know we
admonish you to keep it short.
Yeah, well, we talked about the Confederate Constitution, and I need to tell you it's my favorite artifact in the collection of the Museum of the Confederacy. Anybody wants to come see it, I'll roll it out for you, 10 feet long. 2 points. Number one, how important was it to have a Constitution? They created a committee on February the 4th, and on February the 8th, they signed it. It was the first thing they did. They said the most important thing. I showed it to Margaret Thatcher and told her that while the Iraqis were spending their second year debating their Constitution, Margaret Thatcher says, take this story to Baghdad and tell them about it. Okay, now, we talked about things that changed. The biggest thing is they didn't change much. It was a cut and paste of the U.S. Constitution, most of it. They clearly made state sovereignty more clear. They clearly made slavery and the power to own slaves more clear. They made under God more clear. They created the importance of the supreme being more clear. Then, fascinating, they gave the president a line item veto. By God, I wish our Constitution had it. And let me tell you the first time that Jefferson Davis used it, which was 18 days later. One of the first laws that the Confederate Congress passed for the benefit of us here in Virginia, who, our number one export was slaves to the Deep South. So they passed this law. The Constitution says you can't import slaves. Now, Virginia is not part of that Confederacy in February. So they passed this law, and it's a shot off Virginia's bow. We need you to join us. And it says, if we catch any slaves being imported from Virginia, they didn't write out from Virginia, but that's what they meant. one of three things will happen. One is we're going to send them back to the state from which they came with the written authorization of the governor of that state that they will be treated there as free men. Well, that ain't going to happen. Number two, we will send them to Africa with the written authority of the governor of the state from which they came and the money, and that they will be treated there as free men. Well, that ain't going to happen either. And the third proposal was, if we catch anybody importing slaves from a foreign country, we're going to sell them at auction with half of the proceeds going to the Confederate Treasury and the other half going to the guy who ratted them out. And Jefferson Davis exercised his line item veto. He said that third provision is unconstitutional. We just wrote a constitution that said we can't import them. You can't say we can't import them and then this is what we'll do with them when we do import them. And I think it's an interesting application of the concept of a line item veto and the importance of a constitution.
I think and I'm going to wrap up this topic, but I think the three of you have touched on something that's very important about the rule of law and the way it is perceived, perhaps not then so much as later in the 19th century and certainly early in the 20th century. And that is the rule of law perceived as formal legality. That the rule of law is a mechanism by which governments maintain an orderly society. And that includes the economy. And of course, you have hinted at the conflict between the northern industrial economy and the southern agricultural economy and the loggerhead that presented and the contribution that made in terms of both viewing the other one as somehow corrupt. The other sense of the rule of law is what we call the substantive legality of the rule of law. That the rule of law, to be effective, must mean something. In content, it should be good. Now, that opens up a big can of worms. Who defines what's good? But for the abolitionists, it was very clear what the good meant. And one of the questions that actually Waite brought up early on in our conversations was the whole issue of people like Nat Turner and John Brown. Were they terrorists? Were they revolutionary saviors? Well, it depends on where you lived and what economic stakes were at hand.
Can I just jump in on that?
Absolutely.
Point? That's an interesting question. Turner and Brown, well, both of them, of course, executed by the state. Most Americans were in lockstep in condemning what they did as illegal, as beyond the pale. But Turner and Brown represented an argument that was way too radical for most Americans, but that was also impossible to suppress. And it was the argument that slavery was a state of war, and that the only way to undermine slavery was to bring violence to bear. And it was a notion, furthermore, that slavery was maintained by systematic terror. What defenders of Turner and Brown argued, in effect, was that every other means had been tried, that moral suasion, that again, particularly in the absence of free speech in the South, had not gotten the anti-slavery cause far enough, and that in some sense the violence was a justifiable last resort. And it's important to note, when one mentions Turner and Brown, the sort of extent and cost in blood of anti-abolition violence. Abolitionists feared for their lives wherever they went. They didn't deign to go into the South, but northern mobs attacked abolitionists and dragged Garrison through the street with a rope around his neck and burned down a hall in which some Pennsylvania women were meeting to protest slavery, and so on. And so there was a sense that James Henry Hammond, famous secessionist, said, and I quote, "Abolitionism can only be silenced by terror or death." So the notion that, the idea that terror suffuses the system, that the slave system relies on systematic terror, was an idea that was sort of pushed by the most radical abolitionists, but that was sort of too much for most Americans.
I hate to do this. I do draw the analogy between John Brown and Osama bin Laden. Because each one of them decided that they were going to respond to a higher law. And so one of the questions is, okay, who gets to decide? Because if anybody can decide, I'm talking to God, and God told me that what I was doing is right, total lawlessness. The place where it falls apart, the analogy falls apart, is the reaction in the much of the North to the John Brown raid, where it was disclosed that most of the money came from the North, and the Northern newspapers called him a hero. Now, I was in New York on 9/11. If it had been disclosed that most of the money had come from Connecticut, and the Connecticut newspapers had called Osama bin Laden a hero, I would have gone and gotten a pike and crossed the river and tried to invade Connecticut myself. I mean, you know, so the reaction of Southern people to not the insurrection and the murder, but the reaction in the North, and the fact particularly that the money had come from up north. And I don't care if it came from a small group of people or a big group of people, but it came from up there. So therefore they are our enemies, and we are at war. Somebody, I can't remember, is a smart person, not somebody like me, said that Henry Wise, the governor of Virginia, made a huge mistake. And the mistake was he had John Brown tried in state court for state crime, and he should have said it's a federal crime. Now, I ain't sure exactly what he would have been accused of on a federal basis, but it would have muted the regional, sectional, whatever of it. And I don't know how to analyze that, but I do think that this distrust that goes beyond, Christie talked about it very well, of what Southerners thought of Northerners and what Northerners thought of Southerners. Well, you know, the Southern thought of what the North thought of John Brown was a dominant factor in the election and in the behavior.
Christie, final comment?
None.
Okay. But the issue that came out of all this is this conflict between a moral content and a structural content. And that clearly plays out in the struggles going on between North and South politically and socially. The third issue, and I know how important this was to you in our earlier conversation, so one question on the war powers and the federal authority during the war. Some of the major debates or some of the major issues that gave rise to debates we've already mentioned. One is the constitutionality of the draft, the income tax, confiscation, emancipation, martial law, suspension of habeas corpus. I'm just going to throw all of that out there and ask the question, what part did these things play vis-a-vis the rule of law on both sides of the Mason-Dixon line?
Let me try
and you have 1 minute.
Yeah. I think the most important rule of law that was pulled out of a hip pocket during the entire war was when Ben Butler met with 3 slaves in Fort Monroe in May of 1861 and said, "We are at war. The rules of war say that I can confiscate war-making property. You Confederates say that these 3 gentlemen are your property and they are being used to make war against me. I have therefore confiscated them, declare them contraband of war, and free them." And that decision changed everything. I think it's the most important application of an honest-to-God rule of law during the war that changed everything.
Let me sort of add to that, that you really, for Davis, it's a fairly simple situation. These are two independent nations at war, and therefore the laws of war will govern the conflict. Lincoln has a dilemma. He doesn't want to recognize a confederacy as an independent nation or as a belligerent that would come under the laws of war. He's not sure whether to treat the uprising as a sort of, or the federal effort to put it down as a kind of big police enforcement operation against rebellious citizens rather than as a war between two independent states. So he has this kind of dual view of the war. And he finds it impractical ultimately to stick to this line that the Confederacy is not a nation and therefore not a belligerent and doesn't come under the laws of war. He does all kinds of things, a blockade, a prisoner exchange cartel, this confiscation measure, which treats the Confederacy as a belligerent. Lincoln seeks clarification in the laws of war. It's a pretty fuzzy concept at the time. So he commissions this Prussian veteran of the Napoleonic Wars, Lieber, to write up a code that sort of crystallizes the best thinking of the age on this topic. And he produces this document called the Lieber Code, which reverberates in discussions about human rights to this day. And the Lieber Code really enshrines the principle of military necessity as the sort of key issue. Military necessity is the general standard for deciding on the legitimacy of military action. If you can say that it was necessary, then it's legitimate. And there was a broader notion at this time than there is of ours of what counted as legitimate. You could starve civilians, you could besiege towns, you could ravage the landscape. If it was a military necessity, it was consistent with the rule of law. Lincoln again and again justifies all the congeries of policies that you mentioned, habeas corpus and the draft and confiscation and emancipation, by invoking this concept of military necessity. I'll sort of read you a quote from a letter in which he's trying to justify emancipation to one of his critics, because it gets to the heart of this. He says, "I think the Constitution invests its commander-in-chief with the law of war in time of war. Has there ever been any question that by the law of war, property, both enemy and friends, may be taken when needed? And is it not needed whenever taking it helps us and hurts the enemy?" He goes on to say, "Civilized belligerents do all in their power to help themselves or hurt the enemy, except a few things regarded as barbarous and cruel. Among the exceptions are massacres of vanquished foes and non-combatants, male and female." Well, that's a pretty broad berth there for a military necessity, and it has to carry a lot of weight. And Lincoln only moves from arguments based on military necessity to more stirring moral arguments sort of later in his presidency in the famous second inaugural.
This is a sort of a personal question. When Lincoln passed the draft or called for the conscription of local militias, I believe Congress was out of session, was it not? And didn't he invoke that under Section 2 of Article 2?
I mean, right. For the draft, the idea of compulsory military service is not unusual. Militias represented compulsory military service. What was unusual about the draft was the federalization of that compulsory military service. And Lincoln believed that he was well within his rights, and that Congress was well within their rights. Him as commander-in-chief, Congress in its sort of constitutional authority to raise an army, and Congress, of course, passes an Enrollment Act, which ratifies Lincoln's understanding of this.
I agree with what Liz said about the Lieber Code and all that kind of stuff. But then, if either side and both sides just trampled all over the rule of law, and to me, the most egregious thing of Lincoln's was he didn't think he was going to get reelected in 1864, was trailing in the polls, running against a peace Democrat. And so he says, I need more electoral votes. Let's create a couple more states. And you show me constitutionally how West Virginia was created or how Nevada was created. Nevada is a great one. To make a state out of a territory, you needed 60,000 people living there. And there was 21,000 people living in Nevada. And Lincoln said, okay, that's good enough. That's a state. I need the electoral votes. And that's nowhere in the Lieber Code. I mean, but it was political necessity, not military necessity.
But sometimes I should note, just as to add to what Wade's saying, is that sometimes this Lieber Code and this notion of military necessity was invoked in the service of principle and not politics. And I'll give you an example. Of course, the Union begins to enlist African American troops, and Jefferson Davis orders that they're going to be treated, for all intents and purposes, like slaves in rebellion. If a black man in blue is captured, he's going to be sold back into slavery, whether he was free or slave or not, and whether he was free or slave. And his white commander is going to be treated as someone who had incited a servile insurrection. Now, this is a way of saying blacks are not belligerents and not human beings and not soldiers, whatever uniforms they're wearing, and it's a way of suggesting too that their commanders are lawless. Lincoln, of course, stands up to this by threatening to retaliate, and this was within their understanding of the laws of war. He didn't follow through on the threat because it seemed too much even for him, but he threatens to retaliate. But the Lieber Code tries to resolve this by saying, yes, African American men are belligerents. Lincoln and Lieber say it goes against natural law and the laws of war to declare someone to be outside the pale of the rule of law and the laws of war because of the color of their skin. So there's politics but also principle at stake in a lot of these debates.
Christy?
You said 1 minute. She went 3.
Yeah.
Well, I'll
at
give you
least,
3.
At least.
We got one more question, so I'm holding my peace until the last
Okay.
question.
Then I'm expecting you to answer this one.
All right. What a nice setup.
The last issue is the legacies of the war, and we cannot talk about the legacies of the Civil War without addressing the Supreme Court and its decisions, its lack of enforcing its own decisions. And so I'm going to sort of put together two questions. We've talked about secession, and I think we've answered the question earlier. Has the Supreme Court ever really come to a decision about the nature of secession? Wait, you sort of alluded to that. I think that the weightier question, perhaps at this point, many historians and legal scholars agree that in decision after decision, the Supreme Court did little after the war and the passage of the 13th, 14th, and 15th Amendments to assist freed slaves in achieving their rights as citizens. What were some of the political issues at the time that impeded the court from applying the rule of law equitably?
I don't think there were any impediments to that were legal. The impediments was that the nation was, after the war, the nation went on into this reunification phase. You know, granted, there was Reconstruction, whatever that was supposed to mean, but in essence, it was about reunification. And so many of those, oh boy, okay. Reunification of a nation, but really it was about reunification of white America and trying to reestablish what the new moral center would be, trying to establish what basically this idea of brother against brother and how do we bring our house back together. And there were two interesting things that grew out of that structure. And the most, I think, detrimental to our nation as a whole is that the role of African Americans completely is obliterated from the narrative. Is completely obliterated from the narrative. Immediately it becomes a discussion that this was not a war over slavery. Then it becomes a conversation about, quite frankly, we are still astonished. Wait, we'll tell you, we are still astonished at the numbers of people in our own nation who have no sense whatsoever of the 200,000 plus black men who served during the war. Have no clue whatsoever. People completely erased. And the reason being is that it was deemed important for the power base, if you will, to come back together, to reunify the country, get it working again. Now, granted, there were still a number of people in the North in positions of power in politics who were very angry and continued to be very angry with the South, very angry, and who wanted very much to keep their foot on the neck of the South, to prevent the South from having the level of power and authority that it had. That would lead to secession and led to war. So there was still a camp of folk that were like that, and that sense of bitterness and all of this really brings itself into the modern age. And the courts, the courts ease off. I mean, they take Lincoln's last words quite literally, He says, let them up easy, let them up easy. And that sort of becomes the mantra, so that nobody wants to get into conflict again about what we're going to do with these new people. All right, they're free, they wanted to be free, let them go figure out what to do. Well, here's the remarkable thing of what they did do. The first thing they did is they tried their darnest to reunify families. By 1870, the African American population, the formerly enslaved population, record numbers of marriages, legalizing their unions that they wanted to legalize their unions. Quite frankly, up until the 1965, 85% of African American children were born in two-parent married households. The sanctity of that familial relationship was strong and generational. And you're talking about people who started selecting their own last names for the first time and starting to make these kinds of decisions. I mean, this is he's I think he's scratching. But so, so there was this notion of okay, well, we'll let them go out there. And here's the thing. They did go out there. Many of them did. Several of them struggled to try to find a way. Some of them didn't know where to go, so they ended up back at the places where they had lived and worked before because they didn't have any other options. They didn't know where to go. Others said, adios, I don't care. I'm going to figure this out on my own. They load up their families and they move and they start building communities. And they align with persons who had been free black before the conflicts, who already had certain economic establishments, and started building thriving communities. It is through these actions that we start getting the historically, what we refer to today as the historically black colleges and universities are born during this period.
Can I jump in, Christy?
Yes.
I just want to note that those communities could not protect themselves, and that this is a core problem.
Issue.
And let me just bring us back to that issue of states' rights. And here I'm quoting a scholar named Michael Les Benedict, who said something very smart on this. He said, look, the Civil War kills that extreme state sovereignty doctrine that I described, but it doesn't kill the states' rights doctrine, the more moderate version. And a continuing commitment to states' rights is one of the things that causes the Supreme Court and the federal government to back off in its commitment to Reconstruction. So 15th Amendment, you can't prohibit the right to vote on the basis of skin color and previous condition of servitude, but you can have poll taxes and literacy tests and all kinds of other chicanery that's left in the power of the states. The Klan comes on the scene. The Congress passes some enforcement acts supposed to give the federal government the power to enforce the law, but the Supreme Court, again, doesn't uphold prosecutions under those enforcement acts. So there remains in the North not only a lot of racism, but there remains a commitment to states' rights and a real a sort of squeamishness about what appears to be overweening federal social engineering, as some Northerners saw it.
Right, and this idea of I think it's extraordinarily important about this idea of communities that cannot protect themselves. Right. Our history is full of instances not only of individuals being taken from their homes, but whole communities, thriving communities that were burned to the ground because the people's success was deemed too above themselves. The inability to go and to even do something as simple as to vote, and all of these impediments that were put in the way that were supposedly there, whether you had to pay a poll tax, you had to go through a literacy, whatever it was. And the death knell really is this, one of the major death nails is this whole notion of separate but equal.
Yeah, I could pick up on that. I agree with what most of what Christy and Liz said. I think we've got to be careful with dates, though. I think the period from the end of the war for about 10 years, Reconstruction liberally defined. We passed a bunch of laws. We passed a bunch of amendments. White Southerners were disenfranchised. Black Southerners were enfranchised. Black Southerners, as Christy said, were trying to figure out, okay, I'm free. What does that mean? Let me go find my family and that kind of stuff. In the whole process, it just didn't work. And more than anything else, it embittered the white Southerners, which meant that the sectional divide remained. Okay, now from 1875 to the turn of the century, from a political point of view, Christie just nailed it. Everybody said somehow or another we got to get white Southerners and white Northerners to kiss and make up. And the only way to do that is to get black people out of the way. We can't talk about them anymore. We can't talk about their rights anymore. They're free, but they're not equal. And the culmination is Plessy v. Ferguson, which is 1898. They are separate. They're free. Yeah, right. But they're over there. And that was I love to recommend books to audiences. Get David Blight's Race and Reunion. It is a fabulous book on what was going on in the reconciliation of white North and white South and what happened to the African American population as a result. So that's, everybody write that down. Race and Reunion, David Blight.
I mean, this is all clearly a really challenging topic and a very broad topic, and thanks for bearing with us all. I know we're not done yet, but you know, this is these connections and trying to understand all of this in the context of law. I have to say, was a wonderful challenge for us in trying to frame ourselves that way. But the more we talked about it in preparation for today, we said you cannot separate your times from rule of law. Because they are impacting, and we have to have, at some point, an opportunity to discuss with you all what is happening socially and what is happening politically to our nation as we're trying to, hold up our rule of law and how we are going to live with each other as a community.
Last question, and then we're going to go to some questions from the audience. When Mike and I go into public schools and we try to work with students and teachers and lawyers and judges on teaching young people about the rule of law, one of the questions that we invariably come to ask is a question that I'm going to ask the three panelists, and I'm going to just go right down the line. And that is, in talking about the legacy of the Civil War, what did it teach us about what it means to be an American citizen?
You want to start? Okay, go ahead, Christy.
I think the Civil War taught us, at least I hope that it taught us, that in times of conflict and crisis and ambiguity, that we have a means beyond war to resolve them as a society, number one. Number two, I think that, especially in the 20th century, when we have come to points of mass disagreement, that we have in fact taken them to court. And to try to resolve those bitter points of view. I'm trying to keep it short. Wait.
Thank you.
Echo Christie's thing. The Moton Museum in Farmville is a great example of how Virginia was dealing with the civil rights era of the 50s and 60s, and it was in courts. And a fabulous thing. I think the biggest lesson of the Civil War is we're supposed to be tolerant of people who don't share our political beliefs. When you see the breakdown of political discourse in the 1850s, and I look at Washington, D.C. today, and go, there's a total breakdown of understanding and toleration for somebody who doesn't agree with you. They're all signing pledges and oaths. I want to sign an oath to never vote for anybody who will sign an oath. I mean, it's the a democracy is not a dictatorship. It means somehow or another people of differing beliefs can live together. And because if they can't, you have a civil war. You kill 5% of the population. And so I believe that the legacy is don't do that again. Somehow or another, give some room to the other side.
I'll echo that. I think a lesson is humility. We think we can control the scope of the wars we start, and we never can. These boys who rushed off to war thought this was going to be quick and easy, right? One rebel can kill 10 Yankees and all the rest, and of course it wasn't. So we have to be humble and have our eyes open on that score. I agree with both of my fellow panelists. I think that my way of putting it would simply be that a politics of fear, you reap what you sow with the politics of fear. There was a lot of demonization of the other in this political rhetoric, a lot of misrepresentation and hyperbole and exaggeration, and it really rose the temperature. And then finally, again, freedom of speech is a core right. I think that's a lesson of the Civil War. You can't keep a good idea down. If that idea is equality and emancipation, I mean, every effort was made to keep it down, but you can't. And if you try to, again, you reap what you sow. Freedom of speech is a core right.
Okay, thank you. This ends the formal presentation. I've been given 4 questions. One I'm going to save for last. The first question is directed to Liz. If Lincoln was the defender of the rule of law, how did he justify the suspension of the writ of habeas corpus? Does that same justification apply to the Patriot Act?
Well, the Lincoln and the rule of and habeas corpus, great book on this topic, Pulitzer Prize-winning book from which I will draw, called The Fate of Liberty by Mark Neely, and he's looked at Lincoln's sort of a suspension of civil liberties and asked, as the question does, is this a blot on Lincoln's record? Is this a mark against the great emancipator? And what he argues is that Lincoln, again, invoked military necessity. He said, the people whose civil liberties I am curtailing by the suspension of habeas corpus and by the imposition of martial law are people who are trying to hurt the army. And Lincoln made this argument stick. One of Neely's arguments is that there is surprisingly little outrage in the North about the suspension of habeas corpus and the imposition of martial law, because most Northerners believe that those are being punished. Draft dodgers, bridge burners, saboteurs, and so on deserve to have their rights abrogated. And Lincoln, the great master of words, wrote to one of his critics in response to controversy over Lincoln's clapping into jail an outspoken Copperhead anti-war Democrat. Lincoln says, must I kill the poor farm boy who deserts while I leave the wily agitator who urged him to desert untouched, while I don't touch a hair on the head of the wily agitator? Who's at fault? Is it the farm boy or is it the snake who whispered in his ear? And so Lincoln, this is again, Lincoln again and again is able to sort of explain these policies in this very earthy way to people to justify them, again, in the name of military necessity.
Next question, open to anyone. Did the South's fear of a slave uprising inform the South's bias towards local control?
Can I answer that question by not answering that question? I think one of the most interesting debates ever had in Virginia was in the General Assembly in 1832. It was a year after Nat Turner's insurrection. And they came within one vote of abolishing slavery in Virginia. And nobody knows about it because it kind of got buried under the rug. And there was a tremendous consensus that Virginia should abolish slavery and do a gradual emancipation. If you were born after this date and by the time you turn 18, you'll be free or something like that. But there's one problem that the majority of one couldn't deal with, and that's what are we going to do with them? because it was inconceivable that we could assimilate them into our society, and them and our as white and black. We can't send them out west. We can't send them up north. I mean, because all the northern states, Christie made it right. I mean, perhaps the only thing they hated worse than slavery was black people. We can't send them to Africa fast enough, and therefore the only way to control them is to keep them in slavery. And that won by one vote in the Virginia General Assembly in 1832. The fear of slave insurrection was very real. And if you see the laws controlling slaves between 1831 and the Civil War, they tightened down and tightened down and tightened down tremendously because the white people were scared to death of slave revolts.
The idea of a slave revolt was not one that was an unbiased fear. I mean, this was a reality, and just on short, he's talking about Nat Turner, but you have Gabriel Prosser and all these other kind of individuals. But
Haiti.
Let's not forget Haiti.
Yeah, all right.
Haiti was a successful slave revolt, and when it won its independence and its freedom, the rest of the world shut it down as not being legitimate because it was a slave rebellion. And it has suffered the consequence of that for 200 years. It is the second oldest republic in the free world, behind the United States. And we the world, shut them down because it was a slave revolt. Yes, it was bloody, it was violent, it was all things. And here's the thing, particularly on the peninsula of Virginia, the movement back and forth between Haiti into Norfolk and trade goods and things, the news of this in 1805, people hear, they know this is going on. Then in 1808, you've got Gabriel Prosser, and people are really starting to freak out. So they don't start clamping down in 1832. The clampdowns really start right around Haiti, when you get that second set of very, very stringent things. It's Nat Turner that does the last blow.
That's right.
Let
me add to that by saying there's an ideological clampdown. Because, of course, slave rebellion raises this big, glaring contradiction at the heart of the society. Southerners are beginning to say, in response to the abolitionist attack, our slaves are happy and contented. Now, why would people who are happy and contented and who live in this paternalistic society and so on that's civilizing them, quote unquote, why would they rebel? Well, the answer was they rebelled because those abolitionists get to them. There's this fear of infiltration. And the fear of infiltration is fundamentally a denial of slaves' grievances. A big difference between the sort of defense of slavery of the 1830s and the sort of Jeffersonian defense. Jefferson conceded that slaves had grievances, and that's why whites and blacks could never live side by side, he said. But by the time this positive, good, militant defense of slavery comes around, it's really denying that the slaves have grievances. The only discontented slave is one who's a pawn of the abolitionists. And this is a way of denying the reality of the slaves' grievances and also, in a sense, denying their status as Southerners, right? They're the pawns of Yankees in the minds of people trying to explain away this threat of slave rebellion.
That last piece that's a result of the Nat Turner Rebellion is that Virginia passes the law that now makes it illegal for them to read and write. It really had talking about 20% of a national population, and in some southern communities, the black population is the majority.
And one thing has to really be said in connection to the question as it was posed, and that is on this question of localism. The fear of slave rebellion motivated Southerners to want that strong arm of the federal government to help them as much as possible at those moments. And that's the essence of the Fugitive Slave Act is let's have a federal enforcement mechanism to go catch our slaves for us, because when it could secure the safety of the slave system, federal power was fine.
Yeah. Right.
Last question, what is the rule of law? There are 4 qualities to the rule of law. 1, it must be by the consent of the people in whom the law is vested. The laws must be announced in advance. You can't have retroactive law. You can't punish someone now for driving 45 miles an hour that was in the past. There must be an independent judiciary. The next part of the question, can the rule of law be wrong? Can the rule of law be wrong? No, because the rule of law is an ideal. Can the law be wrong? Yes, the law can be bad, as we have seen in our discussions tonight. That comes back to the idea of the substantive legality, that the law, the content of the law, must have a moral anchor, if you will. There are lots of countries today that claim the rule of law as legitimizing their governments. And they're despotic. The Arab Spring has proven that. Libya has proven that. I'm sure if you got Gaddafi in this room and said, do you have the rule of law in Libya? Yeah, we have the rule of law. But does the rule of law as he defines it meet what is considered to be international definitions? No. And so the law itself can be bad. We've had our own bad laws. Laws addressed against groups of people, ethnic groups of people, the near genocidal treatment of the Native American. That was based on law. The next part of the question is, if so, by what legitimate means may the rule of law be made right? I think the question confuses the rule of law with the law. Laws, little l, and an S. Those laws can be bad, as I've said. And yes, there is a way to correct it. We correct the bad laws within the mechanisms provided by the rule of law. And if we can't do that, then we abrogate our position as citizens. And that's why we're involved in the Rule of Law project, because we fear that if as citizens we don't promote, we don't protect, we don't guarantee the rule of law, then we will lose it. And the civil discourse, the polite public civil discourse that's currently missing, will only get worse. And as it gets worse, the rule of law becomes weaker and we become less secure in our citizenry. Finally, to wrap up what the panelists have said this evening, the dilemma of the rule of law embedded in the Civil War still divides us among familiar fault lines. But fate, divine intervention, or necessity, indispensable, the war became a fiery trial to judge not North and South, not popular sovereignty nor sovereign government, not the rightness of legislated law nor the practical value of higher law. Rather, the war would judge the idea that the rule of law applies to all people equally, and that all people have an equal chance in life, that all people are free. Lincoln also noted in 1838, as a nation of free men, we must live through all time or die by suicide. Where have we heard that before? In this sesquicentennial year of that fiery trial, we must honor the legacy of the lessons learned from this nearly suicidal experience and become, each one of us, preservers of the Union by protecting and promoting the rule of law for all time and, most importantly, for all people, because we are our brother and sisters' keepers. Thank you and good night.
Well done. Well done.
Before we say goodnight, we chose purposely the title of this program tonight, The Rule of Law in the American Civil War, a Dilemma. I would like for you all to give a rousing round of applause to the talent assembled today, because we've added measurably to the conversation about that dilemma. It's not about solving it, it's about recognizing it. And recognizing it in a way that allows us to continue forward with the idea that the rule of law is the basis of all civil society. And thank you very much, all of you panelists, for being with us.